Dear God in heaven, we thank you for this opportunity to come together. We thank you for the messages that have brought us thus far. As we head into unprecedented times, we pray for more understanding of not what's going to happen to tomorrow, but what has happened in the past, what history we're living in at the moment, so that we can understand the future. So guide and direct our thoughts and our discussion. We ask in Jesus' name. Amen. Okay, so I want to continue sharing thoughts on the Sunday law, and I don't want to take much time at all in reviewing what I've done in the past, except to say that one of the symbols of Sunday law that we derive from Acts 27 is Fabius Maximus, Quintus Fabius Maximus Gurgis, the delegation that was led of Rome to Egypt in 272 BC. And the thoughts that I'm going to share today regarding that name are based on feedback that I've received on the previous studies. And I'm grateful for all feedback, positive and negative. It's all been very helpful. So based on that, I want to continue the thoughts on Quintus Fabius Maximus Gurgis. So we gained from 272 BC, which we dropped down into the time period of the Pyrrhic Wars because of the number 273, and that brought us down into this history here. What we did was we looked fully into his name, Quintus being his prenomen, fifth, being the fifth son or the fifth month. That's why you were named Quintus. You were either born in the fifth month or you were the fifth son. Fabius comes from faba beans, which were used for elections and voting. Maximus Gurgis, maximum flood, which is the word that we connected with Sunday law for various reasons that we've reviewed. And just to clarify, when we're talking about Fabius and we're using symbols, the literal here is not voting. The literal is they were bean farmers. That's where the Fabius came from. They were literal bean farmers. The spiritual application is what is used for elections and voting. So that's not the literal. They weren't called Fabius because of anything to do with elections. They were called Fabius because they were bean farmers. So literal and spiritual is a rule that we need to follow when using symbols. So Quintus, fifth son or the fifth month. So what we did was we went to the calendars and we went to the Roman calendar in the time of Quintus Fabius Maximus Gurgis. And if you were born in Quintilis, then you were born in the fifth month and often given that name. Now, we associated that with Trump because he is the fifth president and he will also be the seventh. And we note in previous studies that fifth and the seventh are the same. So that Roman calendar notes the fifth month as Quintilis. When we drop that down to the Julian calendar and also the Gregorian, that equates to July. And July, it was changed from Quintilis to July by Julius Caesar. He named it after himself, Caesar being the punitive word for elephant. And we noted that in July of this year, the year of elections, that the Republican National Convention would be held between the 15th and the 17th of July. Julius Caesar being very significant in this time period. His official title was dictator, and towards the end of his life, he was called Dictator Perpetua, Dictator Perpetuus, which is dictator in perpetuity or dictator forever. He was precariously balanced on the cusp between the old republican system and the new autocracy that would be under Augustus. Many Romans treated him as the first emperor. He was considered the founder of the system of one-man rule. And one of the first things he did when he became a dictator was override the system of quasi-democratic voting. So he effectively started choosing Roman officials himself. That was one of the first things he did. So that's July. And I just want to quote a late night comedian. Now, I'm not suggesting late night comedians are prophets, but I did take note of this particular. He said that he joked like American History Volume 1, 1492 to 1877. But in future generations, the textbooks will be called American History, first half of July 2024. Because that's how the first half of July was seen. It's just like this huge, significant historical events all happening in one half of a month. I mean, he gave it the joke in the middle of July. So nobody would deny that July hasn't been huge or wasn't huge and a significant month. But one of the comments that I've received regularly, well, not regularly, but similar comments that I've received from people is that isn't our test sexism? Where do we see sexism here in these events of this month? In particularly, I guess they were referring to the Republican National Convention. So I just want to go over some of the events. I actually want to concentrate on one event of July, but let's first of all review the events of last month. Might do is rub some room. We make a bit more room here. All right. So July 1. Anything significant happen? Yes. The Supreme Court of the United States handed down a decision on Trump v. USA that gave the President of the United States absolute immunity in official acts. So this was a landmark court case, and we'll look at that in more depth in a minute. So that is a significant event of July, Trump versus USA. On July 2, we see the first Democratic congressman come out and call for President Biden to step aside. So that was July 2. July 13, we have the assassination attempt of Donald Trump. July 15 to 18. July 15, the RNC begins, and the Vice President is announced as J.D. Vance. Is it J.D.? Yep. And on July 18, Trump is, and I'm going to write crowned, because that is the language that the journalists used on more than one occasion. And then we're going to come down to July 21. And this is when President Biden officially withdrew from the presidential race. He announces his withdrawal and Kamala Harris announces her candidacy on July 21. So July 21, Biden withdraws. July 22, Harris is now the official, she's not the official, she is the new presumptive presidential nominee. So I'll write Democratic presumptive, because we haven't had the DNC yet, nominee. So quite a lot of significant events that happened in this month. So one person that wrote suggested that they felt that the resignation of Biden and the candidacy of Kamala Harris was more significant when it came to sexism than the other events. They felt it was hugely significant, and I don't disagree with its significance. July 21 is a significant date in Millerite history, and it connects to 2014 and the Sunday Law. So I thought that was a valid point. What I wanted to pick up was sexism. So they could see the sexism in this history. You've got now you've got a woman, not only a woman, a Black woman representing women's rights and intersectionality, and versus Trump, who represents sexism or misogyny and nationalism. So it's just like 2016. So I do believe it's part of the story. So they saw more sexism there than anything else that had happened in July. However, I did point out that they were missing the misogyny of July 18. Now, I'm sure you've all read, and I hope you've read it maybe 2 or 3 times, the article that was put on media broadcast regarding day 4 of the RNC. And let's see if I can share it. It's from the People's World. And this, there were many good articles that share the details of that day, but this was a pretty good overview of day 4. And it's entitled, "This is a Man's World, Republicans' Misogyny on Full Display." On night 3 of the Republican National Convention in Milwaukee, Donald Trump arrived to the James Brown classic, "It's a Man's World." And then regardless, the message was clear: Trump's Republican Party and the vision it has for the future of the United States is a man's world. That article and others similar to it need to be read and understood. I'm not going to go over that article or those the events of that day with you, because I'm hoping you've already done that. If you can't see the sexism in day 4 of the RNC, then you need to watch it. Google it. There's 6 hours of it on C-SPAN that are easily accessible. And I mean, I know, what day is it? It's the 10th of August. And as of my last look on YouTube, there are 11 presentations of Parminder up from this last camp meeting. So there's a lot to watch and do. And I wouldn't dream to suggest that you put aside his studies. But if you can't see the sexism and misogyny of what happened on July 18, really need to look into that. Read that article a number of times. And even if you flick through the recordings, it would be worthwhile. So I'm not going to go over that, because that should be just homework for everyone. Okay, so it stands out. So I want to suggest that Sexism is a theme that actually runs through all these events of July. And I want to go back to July 1. And the Supreme Court's decision, it brings down its decision on the last day of its term. It was a long-awaited decision. They delayed the giving of it for some time. I think, from what I understand, it's because of the contentious debates that went on about this decision within the justices. But it handed down a 6-3 decision on purely partisan lines in a case asking whether presidents may be absolutely immune from criminal prosecution. This was the case brought by Donald Trump and his lawyers in an effort to delay the prosecution brought by Jack Smith in Washington, D.C. for the actions Trump took to set aside the 2020 election by, among other things, pressuring Mike Pence to set different electors in counting the votes. So if we back up, we go back up to August in 2023, Trump is indicted by a grand jury on 4 charges, all relating to election interference, which included the January 6 attack on the Capitol. This is the first time a criminal case has been brought, a case concerning criminal prosecution for alleged official acts has been brought on a president before the Supreme Court. And what the Trump's attorneys did is they filed a motion in the federal prosecution case to dismiss this indictment. And they cited a presidential immunity because of a previous case called Nixon versus Fitzgerald. And we'll explain that in a moment. So they said, Trump's lawyers said, we want this case thrown out. We are claiming presidential immunity. Trump's lawyers argued that the claims of electoral irregularities and voter fraud were efforts to ensure election integrity. So all Trump was doing in good faith was, one of his official jobs as president is to ensure election integrity. And that's what he was doing. He was doing his job. Therefore, he's immune from prosecution because he's just doing his official job. It's a responsibility of the president. Then the Justice Department said, no. What he was doing was criminal. It can't be supported by the Constitution or any legal precedent. So this was brought before federal court, and then it went, the case went before a district trial court. So let's have a look at that. This gets seen on a district trial court. And the judge is Tanya. No, spelling it wrong. Spell it right. I think it is with a Y. I'll correct it later. Chutkan. It's a woman judge. And Tanya Chutkan, it is with a Y. She said, presidents are not kings. There is no blanket immunity for criminal acts taken by presidents. And she gave all her reasonings. So what does the Trump team do? They appeal it. They appeal it, and it's going to go to the US Court of Appeals for the District of Columbia Circuit. So it's going to go to the Court of Appeals, DC. I'm going to write this. DC is the District of Columbia Court of Appeals. And it's going to go to a 3 a board of 3 judges. Those judges are J. Michelle Childs, Florence Y. Pan, and Karen L. Henderson. I might point out that at least one of these, I think Karen Henderson was a Trump appointee from his previous term. So it goes before the US Court of Appeals for the District of Columbia Circuit. They hear arguments in the immunity dispute. It's a 3-judge panel. So the Federal Appeals Court unanimously agreed with the District Court. And I'm just going to bring it up, increase it. Okay, the United States Court of Appeals. So this is a 57-page response. And I just want to read the beginning of it. It's before Henderson, Childs, and Pan, the circuit judges, and they're going to deliver their opinion. And their opinion is filed per curiam. Per curiam means by the court. They're not speaking individually. They want the court to speak as a whole rather than by a single justice. It's a term used when decisions are very significant. And it means to say that this is without bias. We're speaking with unity. So Donald J. Trump, let me make it a little larger. Donald J. Trump was elected the 45th President of the United States on November 8, 2016. He was sworn into office at noon on January 20, 2017, and served until his term expired at noon on January 20, 2021. At that moment, President Trump became former President Trump, and his successor, Joseph R. Biden, became president and began his own 4-year term. Although this sequence is set by the Constitution, it did not proceed peacefully. Indeed, from Election Day 2020 forward, the government alleges that President Trump denied that he had lost his bid for a second term and challenged the election results through litigation, pressure on state and federal officers, the organisation of an alternate slate of electors, and other means. His alleged interference in the constitutionally prescribed sequence culminated with a Washington, D.C. rally held on January 6, 2021, the day set by the Electoral Count Act, for the Congress to meet in joint session to certify the election results. The rally, headlined by President Trump, resulted in a march of thousands to the Capitol and the violent breach of the Capitol building. The breach delayed the congressional proceedings for several hours, and it was not until the early morning of January 7th that the 2020 presidential election results were certified, naming Joseph R. Biden as the soon-to-be 46th president. Since then, hundreds of people who breached the Capitol on January 6, 2021 have been prosecuted and imprisoned. And on August 1, 2023 in Washington, D.C., former President Trump was charged in a 4-count indictment as a result of his actions challenging the election results and interfering with the sequence set forth in the Constitution for the transfer of power from one president to the next. Former President Trump moved to dismiss the indictment, and the district court denied his motion. Today, we affirm the denial. For the purpose of this criminal case, former President Trump has become Citizen Trump, with all the defenses of any other criminal defendant. But any executive immunity that may have protected him while he served as president no longer protects him against this prosecution. So that was their decision. This is a 57-page document, and students of constitutional law have said that this is the most bulletproof argument, bulletproof analysis of the Constitution that you can come to, that there is absolutely no immunity here. So it's not an easy read because it's a lot of legal lingo, but if you can kind of read over the references, it's so very solid. So this Court of Appeals, the panel of 3 women have agreed with the district court with Tanya Chutkan. So the Circuit Court of Appeals panel unanimously affirmed the district court ruling. They concluded that Trump's alleged actions lacked any lawful discretionary authority. I'm reading from Wikipedia. You can look this up yourself. Lacked any lawful discretionary authority, and he is answerable in court for his conduct because former President Trump has become Citizen Trump. We read that. The panel held further that former presidents have no immunity for allegedly violating generally applicable criminal laws while in office, and specifically to commit crimes that would neutralize the most fundamental check on executive power, the recognition and implementation of election results. So what is the most fundamental check on the executive power, on the president? It is the election results. It is the votes. And to neutralize those votes is a criminal act. The panel noted that while the separation of powers doctrine may immunize lawful discretionary acts, it does not bar the federal criminal prosecution of a former president for every official act. And that absolute presidential immunity would collapse our system of separated powers by placing the president beyond the reach of all 3 branches. So what have they said? If you give the president absolute immunity, it will collapse the separation of the 3 branches. The panel concluded that we cannot accept that the office of the presidency places its former occupants above all the law thereafter. Okay. But on July 1, the Supreme Court of America found otherwise. Their answer today is broadly yes. Former President Donald Trump is entitled to expansive levels of immunity from criminal prosecution for any official acts he committed while in office. And it was a 6-3 decision. The dissent in this case was by 3 women justices. So, SCOTUS. So Tanya Chutkan says, no immunity. I should probably write that. No immunity. District Court of Appeals confirms no immunity. And then the 3 justices, the Liberal justices on the Supreme Court, Sonia Sotomayor, Elena Kagan, and Ketanji Jackson Brown. They dissent. No immunity. So here we have 7 women seven women are going to disagree with 6 conservative judges on the Supreme Court, 5 of which are men, and the only division within those 6 conservative judges is by Amy Coney Barrett. So she gives a partial concurrence. So with the decision that's handed down by the Supreme Court, Chief Justice Roberts gives the opinion of the court. The other 5 justices concur, but Justice Amy Barrett, she only gives a partial agreement or partial occurrence, because she actually disagrees with some of the ways they've come to their conclusions. Bad methodology. So she's going to disagree. She's going to agree with their conclusions. She's going to disagree with how they got there with part of it. So that 7 women, this is all that have stood and said no presidential immunity. That's saying something against these 5 men. So what happens now is that this now gets kicked back to the district trial courts. So the Supreme Court has said, yes, they can have immunity for official acts, partial immunity, whatever that means, because nobody knows what that means yet, for unofficial acts. And it'll be up to Daniel Chutkan on the district trial court to work out what's official and what's not official. She's about to enter a nightmare of trying to work that out, because the president will just say, oh, no, that was official. And there'll be an argument about what's official and not official, and it's going to be appealed, and it's going to go straight back to the Supreme Court. So, yeah, so it's kicked back to the trial court to distinguish between official and private conduct. And so really what this means is it's going to be virtually impossible to come to a trial before the November elections. So I want to share with you that's the Court of Appeals. I'm just going to close that. Okay. So this is the decision that was handed down by the Supreme Court on July 1. And what I want to take you to is Sotomayor's dissent. She has about 30 pages in here, starting at around 67. Just scroll down. Here it is here. The beginning of her dissent, Justice Sotomayor, with whom Justice Kagan and Justice Jackson joined dissenting. I'll just take you to the end of her dissent argument. And we'll read the final closing paragraphs. Looking beyond the fate of this particular prosecution, the long-term consequences of today's decision are stark. The court effectively creates a law-free zone around the president, upsetting the status quo that has existed since the founding. This new official act's immunity now lies about like a loaded weapon for any president that wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation. The President of the United States is the most powerful person in the country, and possibly the world. When he uses his official powers in any way, under the majority's reasoning, He now will be insulated from criminal prosecution. Order the Navy's SEAL Team 6 to assassinate a political rival? Immune. Organises a military coup to hold on to power? Immune. Takes a bribe in exchange for a pardon? Immune, 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 immune. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Because if he knew that he may one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That is the majority's message today. So here in this paragraph, she's broken down the majority's message. What they've said is that they want the president to be fearless, to be able to act without worrying whether he's going to get sued or not. So, you know, if he breaks the law, that's okay, because, you know, he might not do important things if he thinks he's going to get sued. So that's her summing up the majority's message. But she's given some very stark examples of what could happen. Even if these nightmare scenarios never play out, and I pray they never do, the damage has been done. The relationship between the president and the people he serves has shifted irrevocably. Therefore, it can't be changed. It's set. In every use of official power, the president is now a king above the law. So we're going to stop there and just mark July as we now have a king above the law. We might just look at let's just go to her last paragraph. Never in the history of our republic has a president had reason to believe that he would be immune from criminal prosecution if he used the trappings of his office to violate the criminal law. Moving forward, however, all former presidents will be cloaked in such immunity. If the occupant of that office misuses official power for personal gain, the criminal law that the rest of us must abide will not provide a backstop. With fear for our democracy, I dissent. So the courts can't protect the people. They will be there to protect the president. And that's an interesting closing to her dissent, because usually with all dissents, there's this polite qualifier where they'll write with respect or respectfully, I dissent. She didn't write anything to do with respect there. She just said, with fear for our democracy. We talk about RBG, Ruth Bader Ginsburg, and her fiery dissents. RBG's got nothing on what Sotomayor has written in this dissent. It's scathing. Okay, so the president is now less like a democratically accountable official than like a little emperor. Now, where did I get that quote from? Let me bring that up. It looks like it's gone. Just give me a moment. I would like to get that quote. Oh, no, and I'm quoting from The Guardian. Let me do that. The Guardian had an article called Trump Presidential Immunity. That was July 1, 2024. The president is now less like a democratically accountable official than like a little emperor, endowed by the court with an all-encompassing right to wield power as he sees fit, much like the way that divine right used to bless the action of kings. There is virtually nothing that he is not allowed to do. And you'll find most of the reputable news sources have written similar. So just want to give some historical context. So we've got Trump versus the USA. And Roberts, Chief Justice Roberts will give his opinion. And Sotomayor, Justice Sotomayor, will give her dissent. And what Roberts is going to cite is a court case called Nixon v. Fitzgerald. Now, Richard Nixon was president in the 1960s, and you would all be familiar with the Watergate scandal, which has been spoken about in this movement before. But after he was out of office, he was sued by somebody. So in his official capacity as commander-in-chief, one of his official duties as president, he fired somebody. He fired somebody from the Air Force, I think, Fitzgerald probably. And they sued him after. So I think this was in the 1980s. So this went all the way to the Supreme Court. And the Supreme Court decided that he is immune, that presidents in their official capacity should be immune from civil lawsuits, especially this was to protect them from frivolous litigation. So he hasn't committed anything criminal. He's just in his capacity as boss, he fired somebody. So presidents have a certain amount of immunity. And this was something that the founders of the Constitution discussed and were aware of way back in the beginning. So they had talked about immunity and they knew what they were doing, and they never gave full immunity to the president. They did give immunity to the members of Congress. So it took here until Fitzgerald where the Supreme Court made it clear that presidents in their official duties were not, they didn't have to worry about being sued, being taken to court. So, but what else was going on at that time is that there was a civil war, sort of a civil war. You had a lot of protests against the Vietnam War. And what Nixon wanted to do was stop the protests. And so again, so he was questioned about this. And there's a famous quote from Nixon where he says, when the president does it, it's not illegal. And that was something he said in an interview to David Frost, a BBC journalist. So it was very shocking at the time, and it gets quoted a lot. When the president does it, it's not illegal. Because he thought there's this civil war going on. I've got all these protesters on one side and me, the government, America, on the other side. So we need to be able to push back against the protesters. And of course, that would tread on free speech and the right of, peaceful protests, etc. So you've got all this happening at the same time when the Supreme Court are deciding about presidential immunity. So there's two things. They want to protect the dignity of the office. They don't want the presidents just to be sued by every Joe Blow for frivolous things. and they want the president to be able to just do his job without, without worry about being sued. The commander-in-chief needs to hire and fire. So what the game changer here is firing somebody from the Air Force was not a criminal act. Now we're actually talking about something that's criminal. So what Roberts did in his opinion is he's drawn a lot of lines, and this is where the confusion and the mischief will come in, because the president has official acts, which is the core of his duties, and then outside is what he called the outer perimeter of unofficial acts. So where do you draw the line between an official act and an unofficial act? And that's going to be the job of Tanya Chutkan in the district court. So if you think of the power to pardon somebody, and Sotomayor talked about this, and so did Roberts. So on the 19th of January, the day before the president is not president anymore, he pardons people. Well, what if he takes a bribe from somebody to be pardoned? That's a criminal act. But he will be immune from that. And they've talked about that. They've said, yep, yeah, under this decision, he would be immune from that criminal act. It might be corrupt, but presidential pardons fall within their exclusive sphere of authority, so they can never be prosecuted. And Justice Sotomayor confirms that reading. So if it's outside the official perimeter of official acts, then there is a chance that they could be indicted, but all the president would have to do is say, no, that was actually a presidential act, and I was acting in good faith, trying to protect the country, trying to protect the people, and it would just get fought out in the courts, end up in the Supreme Court, and the Supreme Court will say, yep, it's an official act. So all his job descriptions will be classed as official. So in practice, what it means is that anytime the president says, I was doing it because I was president, he's going to be immune. And then if the courts disagree, it just goes all the way to the Supreme Court. So it's going to prevent a jury from finding out if a president committed a number of crimes because he has manipulated the tools of his office, claiming that he was president in doing these things, and he'll never ever face accountability. So this idea of official versus unofficial conduct, core functions versus outer perimeter functions, there's all these lines that Roberts have drawn, criminal and civil. It's pretty muddy. So it's just, bottom line is he has full immunity. So when we look at this history here, there has been a fundamentally huge sea change from June 30 to July 1. The United States of America is a totally different beast on July 1 than it was on June 30. And this, July 1, is not a Donald Trump story. This is a story about the separation of power. This is a fundamental structural change to democracy, as America has understood it in the past. It's a separation of power story. The Supreme Court have rewritten presidential power. They've expanded the power of the presidency, anything beyond what Nixon would have contemplated. So we've discussed the Fitzgerald case, that it was an official act, and it was actually a private lawsuit. It wasn't anything to do with criminal actions. So it's a totally different question. This is what Roberts is going to be citing here. But the issues there are totally different to what has happened with the 2020 election on January 6. So, you know, this is talking about suing people for, you know, money damages, you know, oh, I got sacked and I lost my pay. And what we're talking here is about a bad faith act, a criminal act. So the $1 million question is what's going to happen about January 6th? So all he has to say is that I was protecting election integrity. I was acting in good faith, but there's no evidence that he was acting in good faith, but it doesn't matter. Evidence doesn't matter. And what the Supreme Court has said is that his motives don't matter. So when it goes to court, they're not even to look at the motives of the president. It is just blanket immunity. He claims he was preventing fraud and acting in good faith. Okay, so we're going to have to wait. So this court case isn't finished, it's ongoing. Now it's, like I said, it's been pushed back to the district trial court. Tanya Chutkan has to decide what's official, what's not official. She has to deliberate on that. Trump's team could appeal, and like I said, it's just going to go up to the Supreme Court and back, and there will be no decision before the November elections. So the public don't get to vote on that issue because there is no outcome. Okay. So Sotomayor's dissent. Roberts is going to cite Nixon versus Fitzgerald. Sotomayor is twice going to cite Dobbs versus Jackson Women's Health Organization. And why is she going to do that? She's going to do that because what the conservative justices use to come to their conclusions is originalism. Which means they want to take into account text, history, and precedent. And what Sotomayor points out rather clearly is that when it came to Dobbs versus Jackson, this was their argument. Where does the Constitution talk about women's autonomy, or about reproductive rights, about abortion? It doesn't. There's nothing in its text. We can't get history. There is no precedent. Therefore, we are, we're overruling Roe versus Wade. It's unconstitutional. So this was their method for Dobbs versus Jackson, originalism. So they used it here. When it came to Nixon versus Fitzgerald, they didn't use it at all. So Nixon versus Fitzgerald, they can't use originalism because the founders did talk about immunity. There is no immunity written into the Constitution. They can't use text, history, or precedent to give presidential immunity, blanket presidential immunity. So up here, they don't use it. And so what she points out is that they only use this when it's convenient. History matters to this court only when it is convenient. They claim to respect text, history, and precedent, but they're definitely not doing that in this case. So what's the only answer to this? How are we going for time? The only way to push back against any of this is through elections. So one thing that does come up in these discussions is 1798, because in 1798, the United States introduced 4 acts, the Alien and Sedition Acts. So the second president of the United States was John Adams, and he was an autocrat. He was openly believed in authoritarian government. And he wanted to silence the opposition until the next election. So what he said, well, you know, we've got this war, which really wasn't a war, they call it a quasi-war with France. We need to stop any criticism against the government while we're at war. Wasn't much of a war. And they brought in these Alien and Sedition Acts. So the Alien and Sedition Acts were, their purpose was to criminalise criticism of John Adams himself and the government. So it deported non-citizens who were subjects of foreign enemies, and it attacked the core of free speech and the free press. He wanted to control political debate until the next election. So his vice president was Thomas Jefferson. Now, Thomas Jefferson was the leader of the opposition party. So back then, the vice presidents were of a different party, were of the opposition party. That changed. I can't remember when that changed, but it was different than it is now. So the only way to resolve the problem there, because editors of newspapers were jailed, the only way to resolve that was to have an election and kick John Adams out, and Thomas Jefferson became president, and he just let those acts expire, and he pardoned all those that were jailed. So that was the answer to the problem in 1798. We recognise 1989 as the time of the end. Information war began. We can see that same information war in 1798 with the Alien and Sedition Acts, and that's been in our movement for quite some time. So why are we bringing this up? It gets cited, referenced here as well, that the framers of the Constitution were dealing with presidential immunity back in the beginning of the country. And the only way to resolve those problems was through election. So all right, so I want to leave that for the moment, and we're going to do a little review ourselves. Oh, sorry. So just note that we're going to mark July as the United States now has a king who is above the law. We're going to go back to the prophecies of Daniel. And this has been in the public record for a long time, so we'll just walk through this quickly. So Daniel, 4 main prophecies: Daniel 2, 7, 8, and 11. Excellent. 2, 7, 8, 11. So in Daniel 2, we have the head of gold. We'll go arms and shoulders of silver, belly, thighs, brass, legs of iron, feet, iron and clay. Daniel 7, lion, bear, leopard, nondescript beast, or as the book of Revelation would say, a dragon, and feet 9 of clay, horn. Daniel 8, yep, we can put an ox there, but let's just go with what's there. So we've got a ram, he-goat, little horn, and we know that we've got masculine and feminine in the horns. Daniel 11, King of the North, King of the North, King of the North. So when we go back to Daniel chapter 2, we know that we're following a theme. And what's our theme of Daniel chapter 2? Thou, O Nebuchadnezzar, art this head of gold, and after thee shall arise another kingdom. So what we have here is a king and a kingdom. Daniel 7, politics. Daniel 8, religion. Daniel 11 is their purpose, the purpose of the King of the North. All right, so we had discussions at our last camp meeting, the camp meeting that was held in Australia down in Aries Inlet, when we were discussing patriarchy and terminology. And the subject came up about kings. And we didn't come to any conclusion, about inclusive language, etc. But let's just consider these prophecies of Daniel, because this represents the antithesis to what? If we look at Daniel chapter 2, we see a mountain, and out of the mountain comes a stone. And if we use parable methodology, we know Daniel tells us clearly that in the days of these kings, God is going to set up another kingdom. So if this is a kingdom, what does it have to have? It has to have a king. So this is a king and a kingdom. So what's the difference then between this king and a kingdom and these kings and kingdoms? What characterized the king that we wrote on the other side of the board for July? That king is above the law. What's going to characterize this king?
Equal to the law?
Under law. When we considered Jesus Christ, so God was incarnated as a human being, and he came as a man-child. He was male. And he was recognized as king. The three magi, they came and worshipped him as king. So why is that not patriarchal? And that is because he is under law. And Paul tells us that, the book of Galatians, he was born under the law. That law is not just the law of heredity. He was subject to the law just like all his subjects. He's subject to the same law as all of his kingdom. And that is his ministry on earth, whether that 3.5 years that he walked on the earth as the leader of the movement, he was subject to law. So this king and kingdom is subject to law. It's under law, not above the law. So I would suggest that it's perfectly okay that we have a male leader of the movement, as long as he is under law. It also validates the fact that we have vows. We have a living document of vows that give us more understanding of our laws. And we say, well, what law are we under? We go, oh yeah, 10 Commandments. But if we sum it all up, we're under the law of the Golden Rule, which really just sums them up. And under that law, we can see equality in all our relationships. So once a king becomes above the law, then it is only a natural consequence that things equality issues will be rolled back. So here's another thought. This king and kingdom are under law. That's what makes it so much different. Why it behaves differently, why it thinks differently, why its purpose is different. But what does that make the mountain? That mountain, it doesn't realize it, but it is above the law. It doesn't act, it doesn't, believe, it is above the law. So, one more minute. So I'm not going to take the time to summarize what I've done. Well, I should a little bit, shouldn't I? Sorry. So we've gone to back to July. And I guess the point of what I wanted to do today was to show how the July 18 was very significant, but all the events of July have some connection with Julius Caesar and the change that America is taking place. We see in July 1 that the president will now have blanket immunity in its official acts and part of its non-official acts, whatever that means. And then on July 18, Trump was crowned as the nominee, and we know that he will ultimately be the president of the United States. So I just wanted to, the purpose of this was to show that sexism can be seen right through these significant events of July, that we see it in the decision of July 1, the decisions that led up to that by 7 very capable women who know how to read and understand the Constitution and apply it, but they were overruled by the conservative judges. And that Sotomayor's dissent, really, if you have a chance to read it, it's about 30 pages. She cites Dobbs versus Jackson twice in that dissent, explaining the wrong methodology that is being used, because how can they say that, oh, we can't make decisions on women's reproductive rights? That's not our right. It's not in the Constitution. No, we'll give that to the states. That's for the states to decide. And yet they can come out on such an important decision as presidential immunity, they can come out and just totally disregard history and precedent and text and, make aggrandize that presidential power. So let's close in prayer. Dear God in heaven, we've lived through amazing times. We know that there is much more to come. The Sunday law it's just a Boston. It's just the beginning. That things will escalate as we lead to the loud cry. Help us to understand what has happened in this history, not to just walk through it with closed eyes, but to study it, to see sexism where it is, to be aware of where rights are being trampled on. So we pray for an increase in knowledge on this subject and corrections where they are needed. Help us to move forward positively as we tackle the events of tomorrow. And we've asked for a blessing on the camp meeting in Europe right now. And we ask in Jesus' name. Amen.